Andrea. I'm here with the Community Language Cooperative, and we are going to be practicing language justice today, and we're going to have simultaneous interpretation in English and in Spanish so that everybody can hear and speak in the language of their heart or how they feel more comfortable. Once we turn on the interpretation, everybody is going to see a globe that is going to come up at the bottom of your screen. Or if you're on your phone or tablet, you're going to see 3 little dots or where it says more, and there you're going to be able to see the interpretation feature. If you are fully bilingual in English and in Spanish, you don't have to select the language, but if you only speak one of those two, please remember to select the globe and choose your preferred language so that you can fully participate of this meeting. Just as a reminder, Spanish is 25% longer than English, so those of us who are speaking in English need to speak conversationally so that I'm able to interpret everything into the other language. Hola a todos, mi nombre es Andrea, estoy aquí con la Community Language Cooperative. Hoy vamos a practicar la justicia del lenguaje para que podamos hablar y escuchar en el idioma de nuestro corazón o como nos sintamos más cómodos, y tendremos interpretación en inglés y en español. Una vez que aprendamos la interpretación, ustedes van a ver un globo en la parte inferior de su pantalla donde van a poder seleccionar su idioma. Si están en su teléfono o tableta, van a ver 3 punticos donde dice más y ahí encontrarán las opciones de interpretación. Si son bilingües en inglés y en español, no tienen que seleccionar ningún idioma, pero si solamente hablan uno de esos dos, por favor, escoge el idioma preferido en el globo en los 3 punticos para que pueda participar en totalidad de esta reunión. Recuerden hablar un paso conversacional, mantenerse en silencio cuando no estén hablando y hablar muy cerca a su micrófono cuando sea su turno de hablar. And we can begin interpretation now.
Oh, I clicked add interpreter, but I guess I have to search for you by name. There we are.
Okay, thank you, Andrea. So a couple of instructions on using Zoom. As I mentioned, this presentation is recorded. You'll be able to view the recording of this presentation as well as our past conversations around rulemaking on the program's website. To ask a question, you can use the chat box on your computer or in the webinar app. You can also raise your hand if you are using a computer or the webinar app on your phone. Or if you are calling in only, you can dial *9, so the star button and the number 9 to raise your hand. We do want this to be a discussion and conversation today, so we welcome questions and comments. However, so that everybody can participate, we are asking that each person limit their questions and comments to about 3 minutes each. So some of the things that we're going to be talking about today have to do with legislation, or state statutes. So the Colorado General Assembly, our state legislature, passes the laws, including the provisions that are part of House Bill 24-1294. Our job at the Department of Local Affairs and the Division of Housing is to clarify and implement the laws that the legislature have passed. So if there's anything we're discussing today that is part of state statute, or I say is part of House Bill 24-1294, that is not something that the Division of Housing can change. We would recommend reaching out to your state legislator or legislators if you have feedback on that. I'm also not going to be able to provide legal advice during the meeting. I may let you know if you have a question or comment that borders on legal advice that I'm unable to respond and refer you to an outside legal resource or attorney. We also won't be answering questions about individual registrations or complaints. If you do have questions about a mobile home park registration or a complaint submitted to the program, please contact us by email or by phone. Our email address is mhpop@state.co.us, or our phone number is 1-833-924-9494. 1147, and we have both English and Spanish phone options. We're going to be talking about rulemaking today, administrative rules, program rules. Those are different terms that I'll use to refer to the rulemaking. There are other types of clarifying documents that the Division of Housing can put out in relation to implementing the program and helping individuals understand the requirements of the law. So we have policies and agency guidance on our website. We also have answers to frequently asked questions. So do know that some of the feedback that we've gotten in previous meetings is going to potentially be part of the rulemaking. Some of it will be addressed in other ways through educational information, for example, on our website. An overview of the timeline for this rulemaking process. So we did adopt a couple of emergency rules. They are now final, and the effective date on those was June 17th. The emergency rules simply updated our permanent rules so that they would match statute and the changes that were part of the bill that passed this year. We are requesting written comments on rulemaking. Our first deadline is this Wednesday, July 10th. Thank you to those who have submitted written comments already. I will then be filing a notice of proposed rulemaking, which should be published in the Colorado Register July 25th. And we will send a copy of what's published out to our email list in our Mobile Home Park Oversight Program newsletter. I'll then be taking additional public comments on the proposed rules. Tentative deadline for that second round of public comments is August 7th. And then we'll be holding a public rulemaking hearing on August 14th in the afternoon. I anticipate the hearing will be in person as well as over Zoom. And we were looking at potentially doing a second round of rulemaking as well. We've been getting a lot of great feedback and comments. We may not be able to cover all of it in this first round of rulemaking. So we'll likely be doing a second round of rulemaking a little bit later this year. So where I wanted to start today was with a discussion of some of the hot topics from our previous public meetings. So we're not going to be able to cover all of the comments that have been made at the previous meetings. If you do want, you are welcome to go back and listen to previous discussions. But I picked a couple out to talk about today that I know were questions that came up at least two of the previous meetings. So the first thing I wanted to go over was some questions that came up around the lot entry notice. So if a landlord is entering a mobile home lot, they're required to, in most cases, provide 72 hours advance notice before entering the lot. So this used to be 48 hours notice. House Bill 24-1294, actually, excuse me, a different bill, House Bill 1098 on for-cause evictions changed that time for entry from 48 hours to 72 hours. So additional notice is now required before a landlord or their agents can enter a resident's mobile home lot. In previous rulemakings, we provided some clarification around what type of notice is needed if a landlord has someone who's reading meters, for example, or entering a lot for maintenance. So I wanted to highlight those existing rules here. So in previous rulemaking, we clarified that for purposes of meter reading, so it's a monthly recurring reading of a meter and a lot entry to do that. The landlord has to provide residents advance notice once every 12 months, at least 72 hours before entering, that specifies exactly when meter reading is going to be done and specifies a specific date range and time range. So for example, we will read your meters the 1st through the 5th of the month between the hours of 9 to 5. A notice can't say we're going to enter your lot at any time to read your meters. It has to be more specific. So this is just a refresher in response to a question or comment that came up at previous meetings. So question, does this affect public utilities and county officials also? This is specific to the landlord or their agents entering a mobile home lot. Wanted to open it up. Any questions, any potential changes to this rule based on the advance notice that is required now being 72 hours? Question, what if management refuses to provide any notice? Then management could be in violation of the Mobile Home Park Act, and the resident can submit a complaint to the Mobile Home Park Oversight Program. And Michelle will provide a link in a moment here to our complaint form and information on the complaint program. A question, wouldn't meter reading be done by public utilities? It may depend on whether the residents are paying a public utility directly or are paying the landlord, and the landlord has hired someone to do the meter readings. We also had some questions and discussion around entering a homeowner's lot for maintenance. So just a refresher, this is in our current rules. If the management needs to enter a resident's lot to complete a specific maintenance or repair project that will likely take more than 1 day to complete, the landlord has to provide 72-hour notice before it starts, talk about the work that's going to be, describe the work that's going to be done, and give a date range and time range for each stage of the work. So this was in response to previous comments, for example, that if a landlord was replacing driveways or repaving driveways, for example, and that was going to take several days, would the landlord have to go onto the lot to post a notice every single day or wait 72 hours between each stage of the work? And the rule says no, but there does have to be a detailed notice that's provided ahead of the work starting. So if there is an emergency, the notice period that may apply may be a reasonable amount of notice. It will depend on what the situation is. Section 38-12-222 is the section of the Mobile Home Park Act that applies to lot entry notices. So a question again, if a water system is a listed public water utility system, wouldn't that be a public utility? I can say that landlord means park owner, park manager, or their agents. So the question might be, is the person who's reading the meter the agent of the landlord? Beyond that comment, I don't think I can provide a specific answer without knowing more about the situation or getting into legal advice. Question about emergencies, what is and isn't allowed. I will pull that up and provide some more information for the chat here in a couple of minutes. What the statute says about lot entry for emergencies. So we were talking about lot entry in previous meetings, specifically related to that change from 48 to 72 hours and related to snow removal. So under current statute, as a result of the bill that was passed by the state legislature, a landlord is now responsible for snow removal for all roadways and for all pedestrian sidewalks and other pavements that provide access to mailboxes, public notice areas, and public buildings. So we got feedback in previous meetings to clarify where exactly the landlord needs to remove snow. Does it have to be from sidewalks or driveways on individual lots, around the lots? What are pedestrian sidewalks that provide access to mailboxes? And then also knowing that there has to be 72 hours notice before entering a lot. So here is what we're currently thinking in terms of clarifications. So the landlord is required to remove snow from sidewalks in front of and around individual mobile home lots, but not sidewalks or driveways on individual lots. So I will stop there. Other questions we're looking for feedback on, or we've been asked for clarification on, or how much snow does there need to be for the landlord to remove snow from sidewalks and roadways? Is it the same amount or different amounts for those different types of pavement? And then by when does the snow removal need to be completed? For example, should it be based on local ordinances that apply to similar residential or commercial properties? So a question or comment in the chat, would a light dusting of snow be considered needing snow removal, or would 3 inches be a minimum? I don't think that the statute says, so we are looking at clarifying that. I'm interested to hear from folks based on their experience, what amount of snow is passable or not passable, and what does your local jurisdiction require? So I'm going to open it up for questions and comments on snow removal. Well, we will go ahead to. Oh, now I'm seeing some questions and comments in the chat. So, question: is this a requirement just for paved spaces? The statute specifically refers to snow removal on roadways, pedestrian sidewalks, and other pavements. So yes, it is just for paved spaces. A comment that in one county, they look at factors like, has the snow stopped? Will it melt? Is the snow light or dense? Usually if it is 2 inches or more, we will rent the equipment, but won't for anything under 2 inches unless it is a heavy wet snow that might not melt. Thank you for that feedback. Another comment: typical municipal rules say 1 inch or greater has to be removed in 24 hours from the end of the storm. Another comment: please try to be reasonable. If not, I'll have to raise the rent to cover these costs. Any other thoughts or feedback on snow removal? Comment: 1 inch is not reasonable. Comment: some mailboxes are at the end of the sidewalk that leads to their home. Just sidewalks or other pavements that provide access to mailboxes is what the statute says. Question about access to school buses or routes. Do those count as areas that need to be paved? Good comment. 3 inches is another landlord's current limit. Comment: our local commercial snow removal removes 3 inches or more. A question: so would we then have to shovel the sidewalk to the mailboxes? That is the question we're looking for feedback on and looking at clarifying. To the earlier comment about or question about lot entry notice, if there is an emergency, So the section of the Mobile Home Park Act on residents' right to privacy provides the management does not have a right of entry to a mobile home except in nope, sorry. Management does not have a right to enter a mobile home, even in case of emergency. When posting notices about entering a lot space, management shall make a reasonable effort to notify a resident of the management's intention to enter the mobile home space. A resident shall not enter a mobile home lot in a manner that interferes with the resident's peaceful enjoyment of the space, except in case of emergency. So that's some of the language in the Mobile Home Park Act. You may wish to speak to an outside attorney for further clarification on that section. Comment that after 72 hours, it's ice, so snow removal probably has to be done. I'm gleaning from the comment, the suggestion is snow removal needing to be done before that 72-hour mark. Also, connecting the lot entry notice to the snow removal requirement. Comment that think it would be reasonable for the community sidewalk to the mailbox to be done by the landlord, but the resident is responsible for the path to the sidewalk on their own lot. A question, so are we saying that a snow event constitutes an emergency? I was not saying that. I was responding to a previous question about lot entry in cases of emergency. Comment that county an individual lives in has a 3-inch rule for road snow removal. A comment about an individual's attorneys charging them a certain rate. A comment if state law requires snow removal would be in violation of the act if we did not come onto the lot to shovel the walk. We are, the program is trying to clarify that through this conversation. So, well, through rulemaking, which this conversation is part of, and this feedback will be part of, taken into consideration. So if you have additional comments on or questions about the snow removal, you have access to chat. Please feel free to continue to put those in chat. Or to submit them in writing, and we will provide a link information today on submitting written comments. So another section that we got feedback on is a section of state law that talks about what happens if a landlord has filed a summons and complaint for eviction against a homeowner, and that homeowner makes a complaint related to the eviction with the Mobile Home Park Oversight Program. So this new section of law does not apply to evictions under section 38-12-203(1)(f). So that is the section of the Mobile Home Park Act that says a landlord can terminate a homeowner's tenancy with 10 days notice for certain, what are sometimes called substantial violations of the act. So if a homeowner is allegedly endangering people or property under the specific language in this section of the Mobile Home Park Act, what we're going to talk about doesn't apply. So if a resident gives a copy of their complaint to the Mobile Home Park Oversight Program, or MPOP, to the court, the state law says the court shall automatically stay a hearing for at least 21 calendar days. So postpone a hearing for 21 calendar days. Our program is encouraged to review and conduct an additional assessment of the complaint during the stay. We were asked in a previous meeting what this means, encouraged to review. It means we're encouraged to review and conduct an assessment, but we are not strictly required to do so by state statute. We've gotten some questions or feedback around who will do the initial assessment, how will the results of that assessment be communicated, if they will be communicated to the parties, and basically what this process will look like. So we're taking requests and recommendations on this new section of law. Note that our program rules can't control what a court does or is going to do, so we would be looking specifically for feedback on the program's review of these type of complaints. So I'll pause for any questions or feedback here. Comments to require a review and assessment within the 21-day period by our agency. The question after 21 days, is the stay lifted or is it indefinite until you review? That needs a rule. I believe the statute does not say that it is indefinite. The court will assess what to do after the 21 days. Comment that needs clarification, as the court could drag it out for months. Our program will not have any control over what the court does. The only things we could control are our review or communicating where our investigation is to the parties. Okay, feel free to provide additional comments on that section, particularly if you have specific suggestions as to what would be helpful from the perspective of a landlord or a homeowner in that type of situation. So the next couple slides, we're going to talk about another hot topic from previous meetings, which was related to reasonable amounts of water, both clarifying what is a reasonable amount of running water in general in a mobile home park, and then what what amounts of water are reasonably sufficient for the landlord to provide to residents when there is a water service disruption. So in black, at the beginning of this slide, in general, landlord is responsible for any water lines or related connections up to the utility pedestal or pad space for each mobile home in the park. Even if a landlord is getting water from an external public utility, the landlord is still responsible for maintaining those water lines and connections under the land that they own, up to the utility pedestal or pad space. And then the Mobile Home Park Act also says the landlord shall ensure running water and reasonable amounts of water are furnished at all times. So the Colorado Department of Public Health and Environment, or CDPHE, is the state agency that primarily regulates drinking water in the state. According to the Colorado Department of Public Health and Environment, under their laws, if there is water pressure less than 20 pounds per square inch, or PSI, that is going to trigger a boil water advisory notice from CDPHE. So less than 20 PSI is when CDPHE considers the water pressure low enough that there is a risk of contaminants. So one thing we're looking at is clarifying what a reasonable amount of water it is, because we've gotten that question. One way we could clarify this is it's amount of water that's greater than 20 PSI at the utility pedestal or pad space, basically where the landlord's responsibility ends. So there's a comment that CDPHE has jurisdiction over a public system and the Division of Housing should not be involved. Therefore, if the park has a listed public water system, then no involvement is needed. The Mobile Home Park Act also creates specific requirements for landlords as it relates to the provision of water to residents, and gives the Division of Housing jurisdiction over this, as well as the Colorado Department of Public Health and Environment. There are a couple of places in the Mobile Home Park Act where this is true. So for example, the Mobile Home Park Act says that landlords have to maintain and repair and pay for the cost of maintaining and repairing all utility lines in the park, including water and sewer lines. That gives the Division of Housing a certain amount of jurisdiction if there's a complaint that a landlord has failed to maintain utility lines, even if, for example, the state electrical board has oversight into electrical permits in a mobile home park. But I think where we can incorporate that feedback is referring to CDPHE or CDPHE standards, so that the Division of Housing is not potentially requiring something different or doing anything different than what the Department of Public Health and Environment requires. So another piece of the bill that passed this summer that we're looking at clarifying, or we've gotten requests to clarify from both landlords and homeowners, is related to the amount of water that has to be provided when there is a water service disruption in a mobile home park. So the Mobile Home Park Act says a landlord must provide potable water, quote, reasonably sufficient for certain purposes that are listed in the Act within certain time periods, quote, after a service disruption begins. So landlords are now required to provide potable water reasonably sufficient for drinking and cooking to residents within 12 hours after a service disruption begins, and potable water reasonably sufficient for bathing and all other essential hygiene for all members of the household within 72 hours after the service disruption begins. So some potential clarifications we're looking at in this section. Based on the program's conversations with Colorado Department of Public Health and Environment, potable water is not a term that they really use anymore. The terminology they use is water suitable for human consumption. So we would be looking at clarifying that's what potable water means to align it with CDPHE's definition. And we've had some questions come up around when a water service disruption begins or when that clock starts for counting the 12 hours or counting the 72 hours. So one way we were thinking of clarifying that is saying the water service disruption begins when the service disruption or low pressure is first reported to park management, the Mobile Home Park Oversight Program, or Colorado Department of Public Health and Environment. The thinking there is for ease of measuring if a complaint were to come in. In some cases, there might be evidence of, exactly when water pressure dropped below 20 psi. In many cases, there won't be, but there'll be a phone call from a resident to say a landlord's emergency line reporting a leak, or reporting that their water's not on. So potentially using that as the starting point for the clock. We're also looking at clarifying that the water service disruption begins, and that obligation to provide alternative water that's safe for human consumption applies even if water is intermittently turned back on during repairs. So, for example, if water was on and off for 3 days, and it was off for more than 12 hours total, but not off for more than 12 hours straight, does this requirement to provide alternative water apply or not? So in the comments, I see a question, is there a number of, support for us not going beyond CDPHE's regulations? Question, is the number of residents in households set by bedroom? So what the statute says is that water is required for all members of the household. It does not define or set limits on the number of people in a household. And there was a bill that passed the state legislature this year that restricts local governments from putting restrictions on the number of roommates in a home. There are certain situations where local governments will be able to still have restrictions, but it's much more limited. So in terms of limiting the number of people in a home, that might be something that would be done through a lease, but is not specifically part of the Mobile Home Park Act. So other clarifications that we're looking at is exactly what amount of water is going to be reasonably sufficient. So one number that we came up with through discussions with CDPHE were 20 gallons of water per person per day for all of the purposes listed in the Act. So this would be the amount that is required 72 hours after the water service disruption begins. And again, this is a proposal, but what we're looking at in rulemaking. We have not narrowed down yet the amount that may be reasonably sufficient for just drinking and cooking, so that 12 hours after. It would be something less than the 20 gallons of water per person per day. A question about whether landlords should add the maximum number of household members to their lease based on number of bedrooms. I cannot provide advice on that. Do know that for existing homeowners, landlords cannot require homeowners to sign a new lease or change park rules related to who can be in the home after the homeowner starts their tenancy. So lease changes would have to be agreed to by the homeowner or for new residents. And there is some guidance on new leases and lease renewals for mobile homeowners specifically that is available through the Division of Housing's website. Rule changes are allowed in mobile home parks, but there are restrictions on the type of rules that a landlord can change that affect the home itself, what can be done in the home or to the home, if a rule is changed after that initial lease is signed. And that is in section 214 of the Act. A comment about needing to raise the rent to cover the cost for an attorney. That is not something that we can generally comment on one way or another. I can, from an educational perspective, let you know that landlords are only permitted to increase rent once every 12 months. Thank you, Michelle, for providing links to our website and the information on leases and mobile home parks in the chat. So we have about 8 minutes left for today's meeting. I want to open it up for other questions, items for discussion. I know I did not cover nearly everything that was brought up in previous rulemaking meetings. We have made note of the comments if you've been in previous meetings. If your first meeting, you have questions, comments, or you're returning, I want to open it up for discussion at this time. Question, what about too much water? Do residents have a right to adequate storm drainage? Great question. The landlord is responsible for maintaining lot grades and ensuring adequate drainage around each home. That is in section 38-12-212.3 on landlord responsibilities. A question about whether a landlord is allowed to enforce current park rule as of June 30th. I think that's probably going to be a more specific question that requires legal advice and not something I can help with on the call. Landlords, generally speaking, are allowed to enforce community rules and regulations that comply with the Mobile Home Park Act, section 38-12-214 on rules and regulations in mobile home parks. That does bring up a question that came up in a previous meeting that I wanted to respond to, though. So we had gotten a question at a previous meeting or meetings, both from homeowners and from landlords, about whether the mobile home park oversight program could review community rules and regulations before they're enforced to see if they comply with the Mobile Home Park Act or other applicable law. And we cannot provide that service. We are not attorneys that represent landlords or homeowners. There was a suggestion that was brought up about potentially creating a task force to provide more guidance to landlords and homeowners on what types of rules comply with the Mobile Home Park Act and what types of rules may not comply with the Mobile Home Park Act. So I think that was an interesting suggestion that folks brought up. But just to clarify, our program can't approve park rules before they're enforced, or generally can't address complaints about park rules before they're enforced, unless it's a rule change and homeowners are challenging that under the act. Question, what assistance does the program provide for landlords? We provide public education and resources, like some of the resources we've been sharing on our website in this meeting today. The complaint program is also available to landlords. Park owners and managers can file complaints or for certain violations of the act against homeowners. Can the program assist landlords with enforcement of rule violations and implementing changes? The enforcement of the landlord's rules and regulations are up to the landlord, provided those rules and regulations comply with state law. Typically the landlord's recourse for enforcing rule violations is to provide a notice to cure or quit, or a less formal notice to residents to correct a community rule violation. Can the program impose fees and fines to tenants? It depends. There are certain penalties that are specifically laid out in the Dispute Resolution and Enforcement Program Act that can be imposed on a respondent to a complaint. So if a landlord makes a complaint against a homeowner, and for example, the homeowner does not respond to a subpoena issued by the division could impose a fee or a fine on that individual. Or if the division issued a written determination and notice of violation against a homeowner, the homeowner didn't take the steps required to comply with that, there could be a fee or fine associated with that noncompliance. In the interest of transparency, I will say that most of the provisions in state law passed by the state legislature that are part of the Mobile Home Park Act are focused on the rights and responsibilities of individuals who own their home and rent lot space. The Mobile Home Park Act, by and large, is written for the homeowners, not the landlords of mobile home parks. So if the program seems skewed toward residents, part of that is the nature of the Mobile Home Park Act and the reason why it was passed to protect people who own their homes, but not the land underneath it. The recourse that landlords have is more through the legal system, through the eviction process or contract enforcement. There are certain things that landlords can make complaints about through our program, but it is going to be more limited than the things that residents can make complaints about. And that's because of the nature of state law. So that could be something to provide your state legislators feedback on. Well, I'm going to skip ahead here to our slide on how you can provide feedback on these rules or other questions to the program. So we're asking for written feedback by this Wednesday, July 10th, which probably means you're going to need to, if you're able, provide feedback by email. So you might remember from the timeline, we're doing 2 rounds of feedback. So if you've put feedback in the postmail and send it to us that way, it will still get reviewed and incorporated, but might not be incorporated into this first draft of the rules. So our email address is mhpop@state.co.us. Please include MHPOP rulemaking or just rulemaking in the subject line, so we know that it's a rulemaking comment. Our mailing address is 1313 Sherman Street, number 320, Denver, Colorado, 80203. And please provide or put MPOP rulemaking, mobile home park rulemaking in that attention or address line, so that we can make sure our program receives it. Again, I'm Christina Postolowski. I'm the program manager. I want to thank everybody for their participation and feedback today. Also want to thank Michelle Gouroulet, our community outreach liaison. And you can contact Michelle for language access or accommodation requests for future meetings. That concludes today's meeting. I'm just going to stay on for a moment here to make sure we save a copy of the chat, but thank you, everyone.